Good morning, Mr. Dodson.
Good morning, Chief Justice. Good morning, Commissioners.
How are you this morning?
I'm well, thank you. And how are you, Chief Justice?
We are all right. I'm responding on behalf of everybody. Thank you very much. Let me begin by welcoming you to this interview and thank you for making yourself available for this interview and making yourself available as a candidate for a position in the Constitutional Court. I think that I must also mention that I thank you particularly that despite the fact that you have been before this body quite a few times, you continue to be prepared to avail yourself and come and be a candidate and come for interviews. I appreciate that very much.
You're welcome, Chief Justice.
Because you have been before this body quite a few times, and most of the commissioners have interviewed you before, although there might be one or two who haven't. The way I'll run this interview will be on the basis that most of the commissioners know you. They've read your CV a few times even before this interview, and they are quite familiar with your career, with how your career has progressed for you to be where you are. So I will work on that basis. However, I must immediately say that when I say that none of the commissioners who might not have interviewed you before must feel that they are not entitled to know you fully. So they are still entitled to know you fully as well. So I will leave room for that. Thank you very much. I'm not going to explain some of the rules that I sometimes explain because you know them, because you have been here before. I'm not going to go through your academic qualifications. They are in the questionnaire. We know them. I will then indicate that after university, you did articles and you got admitted as an attorney. Is that correct?
Yes, that's correct, Chief Justice.
And after 94, you were appointed as a judge in the Land Claims Court for a term of 5 years, which you served fully. Is that correct?
Correct, Chief Justice.
And during that time, as a judge of the Land Claims Court, you produced numerous judgments which got reported. Is that correct?
Indeed, there's a list attached to my CV.
There is a list in the CV, yes. And actually, you have also written extensively, if I recall correctly, in terms of academic articles.
Reasonably extensively.
Reasonably extensively, yes. No, thank you. And after you had finished your term as a judge of the Land Claims Court, you then went to do pupillage and were admitted as an advocate. Is that correct?
Indeed, Chief Justice.
And that was in the early 2000s when you got admitted as an advocate. Is that right?
Correct, Chief Justice.
And you got conferred with silk status about 10 years ago. Is that right?
I think it's 13 years ago
About
now.
13 years ago. So you have been silk for 13 years.
Yes.
And during your time as counsel, you have done a lot of matters which involve constitutional law, administrative law, land claims matters, and commercial matters. Is that right?
Yes.
Have
On
I
a
left
quick-
out something, another branch of law?
I couldn't hear the last question, Chief Justice.
Have I left out another branch of law in which you practice,
I've done a fair amount of labour law.
a fair amount of labor law? Did you also act in labor law, or was it in the competition appeal
No,
court?
I acted, I think, for 2 weeks in the labour court.
Oh, okay. Yes, yes. And you have acted in the High Court a number of times, is that right?
Indeed, Chief Justice.
Have you produced any judgments during your acting stints?
Yes, I have. And
Yes.
there is a list of the reported ones. The list is one short. That LW judgment, which I included in the pack,
Yes.
has also been reported.
Yes. So although you may not be a judge now, you were a judge for 5 years and you produced judgments that were reported. And during your acting stints as a judge or an acting judge of the High Court, you have produced judgments, some of which have been reported.
Indeed.
Yes. Now, previously, we included your name, if I recall correctly, at some stage among the names that we sent to the president for consideration so that he could pick one of 4. Is that correct?
That's correct. I think it was in 2022, Chief Justice.
Yes. So obviously, this body would have concluded that you were suitable to be appointed to the Constitutional Court for it to include you in that list. That's at least how you understand the legal position to be.
That is how I understand it, Chief Justice.
Yes. Since then, one of the things that has happened is that you have been given an opportunity to act in the Constitutional Court. Is that correct?
Indeed.
We'll talk about that just now. Is there anything that has happened to your knowledge since then up to now that could negatively affect your suitability?
No, Chief Justice.
Yes. Now, you got an opportunity to act in the Constitutional Court in the 4th term last year, is that correct?
Indeed, Chief Justice. And again, the first term this year.
And again during the first term. Thank you very much. I'm just reminded that there is some objection that we will deal with in due course. I think that's in relation to the question whether anything has happened since then which may negatively affect your suitability. That issue will be raised and you'll get a chance to deal with it. When you got the opportunity to act, you acted in the 4th term last year and in the 1st term this year in the Constitutional Court. Is that right?
Yes.
Please share with the Commission what your impressions were of the work of the Constitutional Court and whether you enjoyed acting and how you found the work to be.
It was an enormous privilege to spend 2 terms acting in the Apex Court, and I'm most grateful to have been afforded the opportunity. It was intellectually challenging in a good way, in a thoroughly enjoyable way. I enjoyed the hearings. I particularly enjoyed the insight into en banc decision making. The most I've been exposed to previously was in full bench appeals in the High Court, and it was fascinating and interesting to see how en banc decision making works, where you're dealing with, at the time that I was acting, 10 judges working together. I was also comforted by the fact that I was able to fit into that decision making process, notwithstanding the particular path by which I arrived at those acting opportunities. At a collegial level, the judges there were extraordinarily welcoming. They were very egalitarian. treated me with great respect and as an equal with them.
No, thank you very much. You have not been able to produce a judgment, is that correct?
That's correct, Chief Justice, in the
Yes.
sense that one hasn't been handed down. I've
Yeah.
got one that is about to be handed down and another one that is at the read-through stage.
Yeah.
Which means that it's very close to hand down.
Yeah. Well, I can just confirm to the commissioners that the fact that none of your judgments has been handed down has really not been because you have not been applying yourself properly to the work or that you have not been diligent. You have been very diligent and you have been applying yourself. It's simply that because you were sitting with so many other judges, the process does take some time before a judgment gets ready. But I'm aware that one is about to be handed down.
Thank you, Chief Justice.
Yes, thank you. Now, so having acted for 2 terms, you still feel that that's where you would like to be, namely the Constitutional Court?
Indeed, and not just a case of still, I think a case of all the more so.
Yeah.
Having spent 2 terms there and having fitted in comfortably there.
Yes. No, thank you. Now, of course, in your practice, you have done many constitutional cases in the Constitutional Court and in the higher courts. And of course, having acted for 2 terms, you have also been party to many matters that have been heard during the 2 terms in the Constitutional Court, which raise various issues, including how you deal with orders of invalidity and so on and so on. Is that correct?
Yes.
Yes. Now, I just want you to share with the commissioners what comes to your mind as issues that you must apply your mind to when in a matter involving the constitutional validity of legislation, when you have concluded that an order of invalidity must be made. What other issues should immediately come to your mind as issues that you must apply your mind to?
Well, as a starting point, you would, in terms of Section 172(1)(a), be mandated to declare the legislation to be constitutionally invalid. That would be the starting point. You would then move to 172(1)(b), and there you would then deal with the consequences of that declaration. And that would be particular to the circumstances of each case. And the criterion is that a just and equitable award must be made. One would have to think of the impact of the order there on the parties. One would have to think of the impact of the order more widely. And that may result in various things. It might be that, for example, that the order can effectively follow suit from the declaration of invalidity, and retrospectively the legislation could be left invalid without more. Or the court might prefer to limit the retrospectivity of the order of invalidity and only make it prospective, for example. And then the court might also wish to consider whether they suspend the order of invalidity while Parliament is given the opportunity to correct the shortcoming. And it may also be that the court will devise an interim regime which will apply during the period that Parliament applies their mind to the matter.
And thank you very much. And when would reading in and when would reading down arise in a matter, a constitutional matter?
I think it's best to start with reading down, because reading down wouldn't involve an order of invalidity. It's an interpretive device in respect of legislation to try to read it in keeping with the Constitution and to avoid having to make an order of invalidity. Obviously, it mustn't stretch the limits of the language, but that is a possible solution to a constitutional problem. That would be reading down. Reading in would be a mechanism in circumstances where there is a finding of constitutional invalidity, and there is then a need to decide: does one simply strike it down completely, or does one repair the flaw, as it were, by reading in additional words to bring it within the realm of constitutionality?
And do you want to say something about the principle of subsidiarity?
In the context where the Constitutional Court is working, it essentially says that where a fundamental right has been embodied in the form of legislation by Parliament, that is the focus of attention or the focus of attack. It's around the legislation that the attack and the decision-making of the court must take place. You don't look immediately to the constitutional provision that lies behind it. Obviously, if you were challenging the validity of legislation, then you would be testing it against the Constitution.
And the Constitution provides for the jurisdiction of the Constitutional Court in various ways. One of them is that in regard to certain matters, it provides for the Constitutional Court to have exclusive jurisdiction. Do you remember one matter or two matters in respect of which the Constitutional Court has got exclusive jurisdiction?
Well, it would be, there's a list, but the most important ones are where the court is concerned with a constitutional obligation of Parliament or the President.
And Section 177(1) of the Constitution provides for 3 grounds upon which a judge may be removed from office. 2 of those grounds are gross incompetence and gross misconduct. That means that mere incompetence and mere misconduct is not enough to remove a judge from office. That might sound extraordinary to people. What is the constitutional significance of that provision that makes gross incompetence, gross misconduct to be the grounds of removal for judges?
The provision is there to protect the independence of the judiciary and simultaneously to protect the separation of powers between the 3 branches: the legislature, the executive, and the judiciary. The risk, if you don't have a provision like that, is that the legislature, for example, which has the ultimate power, might be tempted to make allegations of mere incompetence, for example, or mere misconduct, in order to remove a judge who's making unfavorable decisions. So that's essentially the reason that you have that provision.
Yes, no, thank you. And lastly, what can you share with the commissioners about what actual severance is and what notional severance is?
Well, severance is similar, performs a similar function to reading in. If one is looking at a solution to a constitutional case or a constitutional problem that doesn't involve simply striking down the relevant legislation in its entirety, you might be able to look to particular words in the statute and see if you could sever them from the statute without destroying the underlying purpose of the statute, but at the same time solving the constitutional problem. So, briefly said, simply deleting a word here and there to bring it within the field of constitutionality. Notional severance would be used where severance doesn't work, but you also don't want to strike down the provision in its entirety. So your order might say, to the extent that the legislation in question has X outcome, that must be ignored. So, I mean, an example might be where, which has come up, where evidence that's elicited in a particular forum, there might be a provision that says that incriminating evidence is admissible, and that might be in conflict with Section 35 of the Constitution. So one might say in an order, to the extent that that provision might be read as allowing the use of the evidence in criminal proceedings, it is unconstitutional, and to put it colloquially, you may not go there, you may not use it. And adding those words, to the extent that, at the beginning of the order, would have the effect again of bringing it back within constitutional bounds.
Thank you. Minister?
Thank you very much, CJ. Good morning, Advocate.
Good morning, Minister.
Yes, the last time you were here, you told us that you were one of the first land court, the first group of the land claims court judges.
Yes.
So I just want to get from yourself, you are now aware that the Land Claims Court Act has been amended or repealed to give way to the Land Court.
Yes.
And it will be operational very soon.
Yes.
On the benefit from your experience when you started with the court, what is it that you think that court could benefit from people like yourself who were there when the land court was started? And what could be the difference now that you will expect the court in terms of the land justice issues that the country is seized with?
So I'm understanding your question to say, what difference does the new act make? How might it benefit land adjudication?
And what do you think the new judges can learn from yourselves who were there when the land court was started, the land claims court?
So I think one of the most important things is it's brought certainty to the institution of the Land Claims Court. And that's been something that's been a hiatus for, I don't know, since I left there, 24 years. And it's good to see that in this round of interviews, people are up for appointment to positions in the land court. And so I compliment you and I compliment Parliament on that legislation and bringing it through. And I know it's taken a lot of initiative and hard work from your side. What is good about the statute, and I hope it isn't necessarily the end of a trend, is that it brings within the jurisdiction of the land court additional legislation which wasn't available, as it were, to the land claims court, such as, for example, the Land Reform Provision of Land and Assistance Act, and the Upgrading of Land Tenure Rights Act, and as I recall, one or two other statutes. And I think that will allow for a more coordinated approach to land issues from one judicial institution. It's also formalized, as I read it, a full court system, so there can be full court appeals within the court, which I think will also help with the jurisprudence. For me, one of and this I think is advice that I would give to, as you put it, to the judges who are being appointed. I think one of the aspects that has real potential is the fact that they have jurisdiction under the Land Reform Provision of Land and Assistance Act of 1993, because I think some of the provisions of that act can potentially be used to provide for the missing leg of land reform. So the missing leg of land reform statutorily has been redistribution. There's legislation to deal with restitution. There's legislation, substantial legislation to deal with tenure reform. There's always been a shortfall, and in fact, there is still a shortfall as far as land redistribution is concerned. But, and I say this prima facie, and if I were to be appointed to the Constitutional Court, I might come to a different view if a matter came before me. But on a prima facie or preliminary basis, I think there is some potential, particularly in Section 10 of that Act, to address the land redistribution problem.
Yeah, my last question relates to what one of the current justices of the Court, when we interviewed him here, Justice Matapo suggested that he believed could elevate or help for expedition of matters to be adjudicated as quickly as possible by the Court, that we should merge the Supreme Court of Appeal and also the Court, and it should work the same way the Supreme Court is currently working, kind of in chambers. So you will understand the language. I heard you speaking about unbanking. I suspect is the opposite of that. Have you considered such a view, or what do you think? Can that help in terms of access to justice for litigants?
I'm not sure that I heard all of your question, but I think you proposed the concept of a merging of the two courts as a means of expediting adjudication and improving access to justice. Is that correct?
Yes, it's not me proposing it. It was Justice Matapo when he was being interviewed. But you are correct. That is the proposition.
I think if something is more or less working, I don't think one must try and fix it or change it. And I think that it is more or less working, the current system. I think that if one looks at the adjudication of all of the respective courts at the different levels, which is something I've had an opportunity to do now while I've been acting there, each has its particular role to play. The advantage that the Constitutional Court has is that they have a limited jurisdiction when it comes to things, for example, like adjudication on factual issues. They don't get involved in purely factual appeals or disputes. And the Supreme Court of Appeal has the capacity to deal with those kind of disputes and to deal with them well. And they have the additional advantage of being able to spread that work, which inevitably is a larger number of cases across panels of the court. They work in panels of 5 or 3. I think that particularly if you look at the history of the Constitutional Court, it was something that arose out of our apartheid past. The parents of the Constitution, as it were, wanted to have a final adjudicative body that was representative and that would make considered decisions on the Constitution and its interpretation and the legislation. And I think that there remains a specialist role of that sort in the Constitutional Court. I wasn't a fan at the time of the expansion of the jurisdiction of the Constitutional Court to include its general jurisdiction. But I've changed my mind. Having been at the court, I've seen that it can work, and I think it can play a meaningful role in relation to developing the law on specific legal questions that are placed before it that go beyond purely constitutional issues.
There was some interference. I don't know where it comes from. Secretariat investigate so that we don't have a repeat. Okay, you may proceed.
Perhaps just to finish off, there are some changes that are needed, though, specifically to Section 1672 of the Constitution. What isn't working at the moment at the Constitutional Court is the requirement that the court sits en banc also for adjudicating applications for leave to appeal in particular. there they should be able to have the same arrangement that the Supreme Court of Appeal has in terms of the Superior Courts Act, to be able to deal with applications for leave to appeal in small panels of 2 or 3. That's urgently needed in the Constitutional Court, and given the Constitutional Court's case law, that can only happen through an amendment of the Constitution.
Thank you, CJ.
Thank you. Justice Mulumela.
Thank you, Chief Justice. Good morning, Mr. Dodson.
Good morning, President Mulumela.
Just following up on your last response in relation to the tremendous increase in the workload of the Constitutional Court and your suggestion that a constitutional amendment might be necessary to enable that court to work in panels of judges, do you think that increasing the complement of judges at that court, which would also obviously require a constitutional amendment, would alleviate the situation in relation to that workload?
It might alleviate the situation, but I don't think it is the solution. I think that there is merit in that design. The numbers on the court are already more than other apex courts around the world. And I like and appreciate the original conception of the court on that basis, a court of 11 judges. So I wouldn't advocate for an increase in the number of judges, but I would advocate for both the amendment to provide for panels as well as an increase in the resources of the court. You know, when the court's jurisdiction was expanded to a general jurisdiction, which inevitably meant a much bigger caseload, I don't think a single resource was added to the court. There was a visit while I was acting at the Constitutional Court from the Chief Justice of Canada and one of the judges on that court. And it was interesting because they have 9 judges in their Supreme Court, and they have a similar caseload. They have a caseload of about 400 coming through the court each year of applications of various sorts. I think the Constitutional Court is around about 360, 370 at the moment. I don't know the exact figure. They have, A, the ability to sit in panels as far as applications for leave to appeal is concerned, B, the ability to sit in panels as far as the hearing of actual matters that are set down is concerned, C, they have what they call the law branch assisting them. It's a team of experienced lawyers, some of them up to 30 years experience, 21 lawyers who are available to the court to assist with preparing memoranda and providing assistance to the judges. That is apart from the 3 research clerks that each of the judges has. So the Constitutional Court has been left behind in terms of the provision of resources to that court. And in my view, that's the solution. Provide the court with additional resources to recognize the expanded jurisdiction, which was several years ago and urgently needs to be attended to with respect.
Yes, thank you. As the Chief Justice has pointed out that you have previously been interviewed by this body before, and the transcript of your previous interviews is available. So my starting point would be that you'd agree that there's no doubt that you are already widely experienced as a lawyer.
Yes, I've been in practice or judging for between 37 and 38 years.
Yes. So what has happened between the last interview and today's interview is that you have now acted for 2 terms at the Constitutional Court. Is that right?
Yes.
Which would that mean that your general profile has been enhanced because you have been exposed to a variety of matters covering all the branches of the law, not only in your hearings, but in your participation in the various applications in that court?
Indeed, President Mulumela.
Okay, thank you. My last question is, what do you think is the justification for the requirement in terms of Section 172 that any declaration of constitutional invalidity by any other court, be it the High Court, the Supreme Court of Appeal, must be confirmed by the Constitutional Court? The rationale for that?
I think the rationale for that is related to the separation of powers. And it is an indication of respect for the separation of powers, in particular between the legislature and the judiciary. And I think it's to promote comity as between the legislature and the judiciary, and a mark of respect that that confirmation would have to happen at that level for it to be effective.
Thank you very much, Mr. Dodson. Thank you, Chief Justice.
Judge President Lambo.
Thank you. Good morning, Advocate Dodson.
Good morning, Judge President.
I just want to check your thinking about what I'm going to raise with you. More often than not, judgments from the Concord are delayed, not because the justices there are not doing their utmost to expedite things, but one of the reasons is that court is flooded. I don't know whether I should say by or with petitions. I'm an African, so English is a fourth language to me. So I just want to understand what your thinking is about how that can be resolved. My take is most of these petitions that go to the Concord can and may be effectively resolved by the Supreme Court of Appeal to start with, and by full courts in the high courts. So I want to know whether you think there would be any benefit if that court were to be strong in terms of granting leave to itself or granting leave to the SCA, where the SCA has not had that matter but simply refused the petition to it. I don't know if my question is clear.
The last part I struggled a bit with, I must confess. I understand that there indeed, and you're quite correct, that there's a problem in relation to an avalanche of applications that are going through to the...
Let me just explain it.
Yes.
A number of the petitions that go to the Concord come from the SCA, where the SCA has refused leave.
Yes.
So I'm saying, is there any benefit if the Concord would grant leave but refer it back to the SCA to deal with the matter?
Yes.
Because I think the CC would benefit a lot with matters that have been dealt with and determined by lower courts, in the same way as the US Supreme Court does things.
Yes, I think that's an eminently sensible suggestion, and I can't say that I saw anything being remitted to the Supreme Court of Appeal during the period that I was there. But also to give you an indication, there were literally less than a handful of matters that actually reached set down. So what one is finding at the Concord is that most of the time the Concord is in agreement with the Supreme Court of Appeal, both when they give judgment and also when they refuse a petition. 9 times out of 10, the Constitutional Court concurs with the Supreme Court of Appeal. So from that point of view, I don't think it's going to make, because they concur, I don't think it's going to make all that much difference. But certainly there are some matters, I think, that might have been set down in the Constitutional Court that could have been remitted to the Supreme Court of Appeal. And in one matter, we would be prevented from going into details because the matter's pending. But it is, let me put it this way, it's an issue that's been discussed.
I see. My last question is, the role of the Concord, one of its objectives is to clarify and stabilize jurisprudence in the country. Now, what's your view about the length of time that justices of that court should ideally serve? I see that if you are appointed, you'll be there for just over 11 years. would it benefit the country if you'd have a cohort of justices who serve quite a longish period together?
Yes, most certainly, because as if judges aren't there long enough, they accumulate the institutional memory, but then as they go, they lose it. So yes, my short answer is I agree with you. I agree with you fully. I'm not quite sure how you resolve it, but what it does suggest is that if you're thinking about people who are coming from the ranks of judges, it means they need to be getting there sooner. That seems to me, from that perspective, to be the only way of getting there. If one applies Section 174(5) to include people like me, for example, that might also provide opportunities for people to get there in time to spend a good chunk of time on the court. I think perhaps the difficulty is that for people, for High Court judges, they have to wait their turn, as it were, to act in the Supreme Court of Appeal. And there are a lot of High Court judges, and there are only so many positions to act in the Supreme Court of Appeal, and they've got to wait their turn. And possibly if that could be considered, it may be that you would be able to get High Court judges coming through the system earlier, both into the Supreme Court of Appeal and then on into the Constitutional Court.
Thank you, Advocate Dodson. Thank you, CJ.
Before I go to another commissioner who will ask questions, let me do a follow-up to Judge President Lambo's first question. Isn't the problem that causes delays in the Constitutional Court this, that one, you have an increased volume of cases that must be dealt with. Two, you have the same number of judges who had to deal with a lower volume many years ago. Three, each of the 11 judges must take part in all the matters that need to be dealt with. Whereas if you look at the Supreme Court of Appeal, it might have, for example, 100 petitions or applications for leave to appeal. But because it is able to dispose of petitions or applications for leave to appeal on the basis of panels of 2, if you have got 100 new applications or petitions in the Supreme Court of Appeal, the 24 or 25 judges in the Supreme Court of Appeal can share that 100 new applications or petitions and divide them by, 12? And with the result that no judge will have to take part in all 100 petitions. Whereas in the Constitutional Court, if there are 100 applications, every judge must read all those applications and take part in deciding them, except where we use 8, which is the quorum. But otherwise, all of them must take part. And that then, one, means for each judge, let's say if it's 100 petitions, if that is 1,000 pages to read altogether, it means in the Constitutional Court, each judge must read all those papers, whereas in the SCA, one judge won't have to read so many. They'll only have to read those that they will be involved in. Isn't that is what takes the time?
Absolutely, Chief Justice. I mean, last night I did some arithmetic thinking about it. I took the example of let's say this. Well, I looked on the website. If you take into account acting judges, the number I counted was 30 judges in the Supreme Court of Appeal. They operate in panels of 2, so you have 15 panels working. So, so if it was 100 cases, they would each deal with 6.6, or let's call it 7. If it was 1,000 cases, they'd each deal with 66. In the Constitutional Court, each judge is dealing with all 365 of the cases. So, in a way, the Supreme Court of Appeal, if they've got 30 judges, has 15 times the resources of the Constitutional Court. The other dimension of it, it's not a big contributor to it, but the other component of it is that there's another level of decision making that the Constitutional Court has to consider. So they have to, if there's been a judgment from the Supreme Court of Appeal, that also has to be considered by the Constitutional Court judges as part of their papers. And in the Supreme Court of Appeal, each judge simply reads the papers, and they sit together and they come to a decision. The problematic consequence of all this is that I think there's the wrong allocation of time as a result in the Constitutional Court between applications for leave to appear on the one hand and spending time on judgments on the other hand. But I think it can be addressed, and the most urgent thing is panels. I don't think that on its own will address it. I think there also needs to be an injection of human resources of the kind that I've mentioned.
Of course, the proposals which we have made public are now to address the issue of the inability of the Constitutional Court to dispose of those new applications in panels. So in terms of the proposal, it's envisaged that we could have, if a constitutional amendment is made, we could have maybe panels of 3. I mean, panels of 3 would make 9, and then there would be 2 judges. If, of course, we say, well, let it be a panel of 2, then we could have a panel of, 5 panels at least. Now, we would still be below the number of panels that the Supreme Court of Appeal is able to have. But it could make a big difference, because if it's a panel of 3, it means that instead of, if you have got 300 new applications, instead of each judge in the Constitutional Court having to read and participate in 300 matters, they will participate at least in 100. If you have a panel of 5 on the basis that panels of 2 can dispose of these new applications, then the load comes down even more. And that is what is sought to be addressed. And of course, the issue of resources and getting experienced lawyers to be employed in the Constitutional Court so that they can do a lot of work like preparation of memoranda, and therefore take off the load from the judges, even though the actual adjudication would still be done by judges.
Indeed, Chief Justice.
That's what the proposal says, isn't it? Okay, all right. Thank
Indeed,
you.
Chief Justice, and as you're aware, I contributed towards the process of preparing that statement, and I fully support it.
Yes, thank you. Commissioner Marmogai.
Thank you very much, Chief Justice. Good morning, Advocate Dodson. When we are interviewing for the Constitutional Court, I'm more interested about what the judge will do as opposed to what the judge has done. And of course, what the judge has done, it's important. I have 2 questions, possibly 3 for you. My first question is in relation to the concept of judicial restraint and judicial activism. There is a sector of the community that says judges don't go far enough. And there are those who are saying judges actually go beyond far enough. I want to understand, in the context of the current legal system that we have, where the courts are continuously called to discuss political issues, issues that have to deal with the decisions of either the executive or the legislature, policy-orientated decisions, budgetary decisions. What should be the approach of the Constitutional Court? Or should it be an individual judge who decides whether he goes into the restrained pocket or the activism pocket, and in line with separation of powers? What should be the actual position, if there is such a thing, of the Constitutional Court?
Well, one would hope that there would be a level of consensus as to the approach to those issues from the court. But of course, an appellate court that consists of more than one judge is designed to ensure that hopefully the best outcome is achieved, even if it involves a majority and a minority decision. I don't think that one can move away from the concept of judicial economy without running into dangers. And that's because of the simple fact that if you don't decide the matter strictly within the ambit of the facts that are before you, you run the risk that another case comes down the line with different facts that demonstrate that to the extent that you strayed beyond the factual dispute, you got it wrong. And you don't want that, particularly coming from an apex court that has nobody above it to correct it. In terms of judicial activism, my own view is that we have a transformational, and if you want to put it colloquially, activist constitution, particularly insofar as it has provided for socioeconomic rights. So I don't think you need to be an activist judge in the way that you might have needed to be in the apartheid era, where you were fighting against laws that were designed to oppress people. And you would need an activist judge who might try to find spaces within that legal regime to defend as best possible human rights. But at the same time, the approach to adjudication must be a transformational approach to adjudication. There are articles based on speeches that were given both by Justice Lange and by Justice Moseneke, which are very helpful from that point of view. And in fact, if you read Justice Lange's article, he specifically warns against the dangers of excessive judicial activism, that you can end up doing more harm than good. I hope that answers your question.
No, thank you, Advocate Dodson. My second question is linked with the first one. When you look at the jurisprudence of the Constitutional Court from Grootboom, Subramani, and then the TAC, which you were part of, and other judgments, it is clear that with respect to socioeconomic rights, the approach has been to take this reasonableness sort of approach. In 1992, Dennis Davis wrote an article where he was arguing against the justiciability of socioeconomic rights. And he pointed out some of the challenges that will arise when these rights are justiciable and they can actually be enforced. And we saw in these judgments some of those challenges coming through. Obviously, I don't agree with his take. But the point that I'm asking, but that I want to engage you on is, while there is this line of reasonableness has been taken, there has also been an idea on the side that actually that is a wrong approach. And the concept of minimum cost should be the guiding principle. I just want to get your stance on that. As a judge who will be sitting in that court, as to what is your view with respect to these two seemingly contradictory positions. While we know a clear position from Constitutional Court, we know what it is, but there is this lingering view on minimum core. What is your stance on that debate?
Well, in the TAC case, I was part of the legal team that was briefed specifically to argue for a minimum core of health rights. And that was the basis upon which we argued that nevirapine should be made available. And we didn't persuade the court as to minimum core. I think that the jurisprudence is settled. I think that you can't, at this point in time, given the number of judgments that have applied the reasonableness criterion, start to walk back on that. And I think that is all the more so from the perspective of the separation of powers doctrine. I think that the reasonableness standard is something that works in terms of the separation of powers. The executive and the legislature are used to being tested on the basis of reasonableness, particularly in the field of Pudger, for example. So there's a familiarity about it, and there's a legitimacy about it. Once one strays into the notion of a minimum core, the court is much more directly addressing how resources should be allocated. And ultimately, that isn't the function of the courts. That is the function of the legislature and the executive.
Thank you very much, Advocate Dodson. Thank you very much, CJ.
Thank you, Commissioner Steinberg. Except if there are some on the virtual media, that was the last one on my list, but I see there are requests for more. Okay, thank you.
Morning.
Morning, Commissioner Steinberg.
I have two questions for you. The one is apropos the last question that the Chief Justice was putting to you. Given that we have very finite resources for the judiciary in this country, and given that we know the high courts, particularly the Gauteng high courts, are in crisis from having not enough judges and support, do you think that if the minister pulls a miracle out of the hat and gets more resources for the judiciary, they would be better spent in the high courts or in the constitutional court in the way that you've discussed with the CJ?
I mean, it's a very difficult question. I mean, the obvious answer is both need money spent on them. But let me be frank. The constitutional court judges work unbelievably hard. They're often exchanging emails at 1:30 in the morning. They work through weekends. They work through public holidays. Judges who are on sabbatical leave continue to work on judgments that are being discussed. They have to attend some of the meetings to discuss judgments. I think they have an impossible caseload. But I'm married to a High Court judge. I know from having acted in the High Court in both Johannesburg and Pretoria that they too work under enormous pressure and strain. So it's impossible to answer. They both need the additional resources. If the resources are scarce, they'll have to be divvied up in some way, and both have a legitimate demand. And that's the fact of life with scarce resources. You're never going to get all that you want, but something needs to be done.
But if the Constitutional Court didn't have to sit on bunk every time, and if only 2 or 3 judges were needed to make a decision about applications for leave to appeal, would that not alleviate the workload a great deal?
I think it would ameliorate the workload a great deal. I'm not convinced that it's a complete solution to the problem. Just knowing how much work goes into a lot of those petitions. Some of them are really complex, number one. some of them require case management. So a case arrives at the door of the Constitutional Court, but there are aspects that need to be clarified. And so a directive goes to the parties to make submissions on a particular point. It'll come back to judges' conference. It'll again be discussed. There'll be a decision, for example, should it not be set down. There's an invitation to then submit final submissions and for the record to be filed and so on. So yes, it'll help a lot. It's not a complete solution.
And then my second question is regarding remedial relief and the powers under Section 1721B in particular. Many of us in practice face the problem in advising clients on prospects of success, particularly in public law cases, because of the wide-ranging discretion the court has after declaring a constitutional invalidity to nevertheless allow for it. And increasingly in private law, particularly in the law of contract, where the public policy considerations have been given more weight. So again, it makes advising clients and their prospects of success difficult. I would also suggest it makes life more difficult for high court judges, who then must rely on a very wide set of considerations and factors when it comes to exercising their 1721B requirements. What do you think the remedy for this is? Is there a way of both finding what is just and equitable in a particular case that happens to be before the court, but also creating some black letter law that provides certainty, which of course is a key feature of the rule of law, is certainty for business people who contract or for people who come to court to challenge something on a public law basis?
It's difficult to think how one could, as it were, tie down the Constitutional Court in the exercise of that discretion. I mean, particularly against, for example, precedents like, I think it was Electoral Commission versus Mhlophe, where Chief Justice Mogoeng said that the discretion is wide, and to use his words, he said that judges should not self-censor in applying the discretion under Section 172(1)(b). So I see only two ways out of it. The one is to legislate. So, for example, in the contractual field and challenges on the basis of public policy to contracts, one way of dealing with it would be to legislate it and to try and get a rule-based system similar to what you have in Germany. If you don't have that, then you're going to have to wait for the jurisprudence to build up. And that really is the other option. In preparing for the interview, I read an article by Marius Pieterse from WITS, who looked at Section 25 and Section 26 and took a holistic view of how the legislation has gone, particularly in relation to the right to housing and cases under PI, Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. And what he demonstrates is that although along the way, because of the very reasons that you give, there has been uncertainty, the jurisprudence has reached a phase where there is a significant level of certainty, and where, viewed holistically, the impact on spatial injustice has been substantial from the court. So That option seems to me to be built into the nature of courts. They work incrementally. They build up a jurisprudence incrementally. And yes, it is frustrating. And because of where I am, I sit in the same position as you. I know the frustration. But I think one has to work towards that. I also think that in the way that one writes judgments, one can be mindful of the need, as far as possible, to provide certainty.
In English law, where a judge wants to, having set aside a decision, and if a judge wants to in any way then allow for that decision to nevertheless stand, there's a list of rules or strict guidelines that a judge would need to follow. Is there not room for a development of the law in that direction?
I mean, it would be difficult to, for the reasons given in relation to the professor's questions, there might be difficulty in the courts laying down a set of rules. I might be wrong about that, and I would need to see I'm not familiar with them, and I would need to see them to see what would be your authority for doing them. If the facts of a particular case that came before a court allowed you to lay down a set of rules, then yes, absolutely, and I think it would be a desirable thing. And when I talk about judges being mindful of creating certainty, there are certainly opportunities that come to look at the case law in a particular case and say, this is where we've arrived at, and I'm now summarizing what the law is. And you see that quite often in judgments. In my Cornwall judgment, for example, that's referred to in my list of cases, that's what I did in relation to rescissions of judgment under under Rule 42. So yes, opportunities do come, provided they're within the facts of the case, to do things like that. And so yes, I would endorse what you say if the facts of the case allowed you to do it.
Thank you, Advocate Dodson, and thank you, Chief Justice.
Thank you. Commissioners, we have just finished an hour with this candidate that we know very well, or most of us know very well. I've got two hands of commissioners who want to ask questions, and I know that those commissioners have interviewed this candidate before. I want to say to them, and they are Commissioner Ngwaitobe and Commissioner Singh, I want to say to them, I will abide by their judgment, but I want them to just reflect whether whatever they wanted to ask is really, really important. If they say it is, I will allow them. But I would be happy if they say, no, on reflection, it's fine.
No, Chief Justice, fortunately, I don't fall into that category because I did not interview this candidate.
How? Okay. I apologize.
So I'm sorry, on the rule you've set, I win.
No, you have. I seem to think I could still see you in my mind asking him questions, so I'm very wrong.
No, but I have asked him questions before, but not in this panel.
Oh, okay. Okay, I'll let you ask the question, and Commissioner Singh will let me know after you whether he wants to ask.
Yes, thank you, Chief Justice. I'm not going to keep you long, Mr. Dodson. The first one is just to make sure that you've had a chance to respond to that complaint stroke objection from the, I think, Mpela community. You know what I'm talking about?
Yes.
Yes. What is your view on it?
Well, I've set out, there was a complaint by a member of the Mpela family, and it came from the Legal Practice Council. I immediately reported it to the Chief Justice because I was, in fact, a sitting judge at the time. I prepared a response and provided a response timeously to the Legal Practice Council responding to it. I immediately made it available to this body to ensure that there was full disclosure to this body. And the complaint, I think, is based in, with due respect to the person involved, perhaps a misunderstanding of the processes. I think the complaint is more against the attorneys. and seems to be related to a bit of a breakdown in communication with the attorneys. There's a suggestion that I hid the outcome of a judgment from the Supreme Court of Appeal. There's an allegation that I said that the case was lost in the Supreme Court of Appeal when it was in fact won. We got less out of the Supreme Court of Appeal than we got out of the Land Claims Court. So my advice in that regard was not incorrect. I didn't hide anything from anybody, and if the truth be told, I'm a bit hurt by the complaint. I know that one should have a thick skin about these things, because I achieved extraordinary things for the Mpela family. They were successful African tobacco growers and other crops who ran an irrigation farm on the banks of the Crocodile River near Tabazimbi. I acted for them for free. Our case was met with enormous skepticism. People couldn't believe that African people could be successful irrigation farmers. I arranged to get the aerial photography from the 1930s. We proved that there was irrigation farming going on. From the aerial photography, the land was still wet from the irrigation. The case was difficult. They'd been awarded market value compensation at the time. It was a reason to abandon the case. I said, let's carry on with the case. Let's find a way. Let's use our ingenuity to try and get a solution. And ultimately, we were successful. The community retained the farm that they'd bought with the compensatory money. They didn't have to give it back, as the Restitution Act provides for. They didn't have to give any money back. And in addition, they were ultimately awarded 86% of the other farm that they lost for racially discriminatory reasons. So it was a result that I'm extremely proud of. And I don't have anything to apologize for or answer for, frankly, in relation to what took place there.
Yes, thank you. We looked at it at the Objections Committee. We thought it had no merit. In fact, when you look at what you achieved, it was actually quite extraordinary. Thank you. The next question I want to, well, this was not a question, so I still have two questions. My first question, I was interested in the conversation you were having with the Chief Justice about why the Constitutional Court is not producing judgments timeously. There is an article by Norina Ali and Leo Bonzia. They point to two other reasons, because they trace the decline in the speed of judgment production from 2013. And they say, it's correct what you say, the expansion of jurisdiction of the court, which is what the Chief Justice has been saying, that has been a factor. But they point to another factor, which is in 2013 was in fact the last year that the court had its full quorum, C-O-R-A-M. So it has not functioned with 11 full-time appointed judges. And so it's, even on the current resources that it has, it's always operating under capacity, which is something that we can solve without doing all of this thing. Let's change the constitution here, let's change that clause. The appointments are within our control. Do you have any comment on that?
I agree with you, as long as you don't offer it in any way as an alternative to panels and an amendment of the Constitution to provide for panels. I agree fully. It's gone on for too long that they haven't operated. It's almost become the norm for it not to have its full complement.
Yes, and absences. They also point out to absences in the court, that even those judges who are available. So firstly, we've got a problem that the positions are not being filled by us. But then those positions that are filled, there are absences there. And that, again, is something we can solve.
Yes.
Now, the next question, the final question I want to ask you is, I was interested in this conversation that was going on yesterday with Professor Bilchitz about what, in fact, is the vision of the Constitution for the. The reason I ask you this, is that I came across an article in 2022, in fact, a letter by the former Chief Justice Arthur Charles Wilson to Judge Kirk Cohen, who was the Judge President of the Transvaal at the time. It's a 1994 letter. And this is what it says. I just want your comment on this. It says that, so he's being congratulated for being the president of the court, so he's responding to accept graciously the congratulations. But then he says, and then Cohen says to him, we're going to help you, to build this court. So he's trying to say, no, I don't actually need your help. He says, we will start with a clean sheet with no precedent to bind us. And we will have the responsibility of giving life and substance to the provisions of the Constitution. So I just want to ask, whether that vision in what you have seen, given specifically your time as a practitioner and as an advocate, whether in fact we are building the new Constitution, or what we have done is to just revert back to old precedent, particularly in areas like contract, property, delict, and crime, which are the core areas of the common law. Because sometimes I fear that instead of building a new jurisprudence for a new country, it's much easier for judges to just see what the judge said in 1956 and just apply that. And given that you've had to apply a new statute, the Land Restitution Act, and where you truly had no precedent and you were operating from a clean slate. So where are we in this debate in the Concord of actually this is a court for a new constitutional order, and it is not a court that is merely intended to regurgitate vices of the common law?
Thank you. That's a very thoughtful question. The system of precedent has upsides and downsides. I think it was Professor Alan Dershowitz who said that the way that you argue and win cases is by persuading the judge that somebody thought about this long ago, and it's already part of the law. But there's a downside to that, because there is a gravitational pull of the existing body of case law, a strong gravitational pull. And I acknowledge that, and I accept what you say. And there is always a danger that that gravitational pull impedes progress and transformational adjudication. The test is ultimately, are we achieving an equal society? That has to be what everybody strives for who is in decision-making positions, whether it's in the legislature, the executive, or the judiciary. We have to strive towards a society that is more equal. And for as long as we live in a society that isn't equal, between those three branches, we are falling short. And I think we need to take that into account as something that inspires us towards rethinking, whether all the time rethinking whether we're on the trajectory that was set for us, and to be careful and to be mindful of that. And if one does that, then I think one can keep that trajectory going. Taking it specifically to the Land Claims Court, I think we got some things right and some things we didn't get right in moving from that clean sheet, and it may have been, in some respects, the gravitational pull of precedent that inhibited us. But I think all one can do is to come back to the concept of transformational adjudication, and in every case that you consider, to think, am I being pulled in the wrong direction here by precedent? Is there another direction that will be consistent with precedent, but that will achieve the transformative goals of the Constitution nonetheless?
Yes, I suppose I was trying to get you to commit to your own vision of the Constitution as a manifesto of transformation, or as an instrument to bring certainty.
I just couldn't hear you, I'm sorry.
I suppose I was also trying to get you to commit, if you want, or maybe not, about your own vision of the Constitution as either a manifesto of transformation or as a legal instrument to bring certainty, because those two are in tension, particularly in the areas of the common law. And I want to know what your own vision is about what the vision of the Constitution is.
as you've seen from my answer, I acknowledge that tension. But my own vision of the Constitution is that it must ultimately serve the purpose of attaining an equal society. And every component of it that we interpret and apply must have that in the background as the ultimate goal to be attained by everybody involved. And of course, it imposes a duty beyond simply the judiciary. It imposes a duty on the other branches of government, but it also imposes a duty on legal practitioners. So, for example, to give perhaps a concrete example of my own vision, I have acted for over a long period of time for the Department of Health in the Eastern Cape. I've seen the incredibly damaging effect of massive lump sum damages award on the health budget. Somewhere between 80 and 90% of people in the Eastern Cape are dependent on public health care because they're too poor to afford anything else. Massive billions and billions of rand are being taken out of the budget to satisfy claims in respect of a small number of people, and around 25% of that money goes as legal fees in those cases. So I've come to the department, got me involved in one case, and I said to them, let's rethink, let's look at what the opportunities are that the Constitution provides, and let's rethink the approach to damages. And we won a case recently in the Eastern Cape, which has completely changed the lump sum damages rule. The lump sum damages rule was established 300 years ago. And we also changed the rule that damages must sound in money and can't be paid in kind. And we established it on an arbiter basis in the Constitutional Court in two cases, the DZ case and the PN case. They said, come back with a properly pleaded, properly evidence-based case, and we'll think about taking this beyond an arbiter. And we've done that. We put an enormous amount of effort into preparing a case and bringing it to the Eastern Cape Court. And they've now done what DZ invited. They've said yes, and they've developed the common law to provide different systems of damages, which impose very, very strict, allow for payment in kind by the department to provide the healthcare that's required for an injured child who's been a victim of negligence at the hands of the state. But ensures that there's the proper supervision as far as that is concerned. And that frees up billions and billions of rand. So that's what I would bring. I would bring that approach. I see a huge opportunity in terms of Section 172, in terms of Section 39 to develop and in terms of Section 173, to develop the common law in a way that achieves a more equal society. And because I won't be able to sit in that case were I to be appointed, but had it not been me who brought the case, I would certainly have decided the case in my favor, if I can put it that way.
I think many of us
Yeah, we
would have
all
decided
would, yeah.
cases in our favor. Thank you, Chief Justice.
Thank you. Before I go to Commissioner Singh, I just want to do a follow-up to Commissioner Ngwaitobi's question that is based on some article by some authors who say, from what he has said, another reason for the delays is when vacancies are not filled in the Constitutional Court. I want to put something to you. I mean,
Yes, Chief Justice.
there's no doubt every institution should operate with a full complement for as long as possible, and of course, over the years, we have struggled to attract in sufficient numbers suitable candidates. That's part of the problem. But when we talk about new applications, the fact that there is one vacancy that has not been filled or two vacancies that have not been filled, does that reduce the number of applications that each judge must read?
No, Chief Justice, it doesn't.
If you have 300 new applications, all those judges, each one must still read 300 applications.
Indeed, and all the Constitution does to say that figure of 8 is a minimum. The principle is that it's en banc decision making. All the judges must participate in each decision, and that's confirmed in the two judgments. Just to give a bit of background, when I arrived at the court, I thought that perhaps the justices of the court were taking too conservative an approach to Section 167(2). And then I, in fact, prepared a memorandum and went and did some research on it. And there are two binding judgments of the Constitutional Court that cement en banc decision-making. They were both judgments that arose out of the litigation in relation to Justice Slaughter, and they confirm, even in relation to applications for leave to appeal, it's en banc decision-making. So, sorry, it's a long answer, but yes.
No,
Chief
that's all
Justice.
right. Commissioner Singh?
Thank you very much, Chief Justice. I'll be very brief, but it's a follow-up question, not a new question.
Thank you.
Follow-up question to Commissioner Ngugaya Toby. Good morning, Advocate
Good morning,
Dodson.
Commissioner.
In your last interview, one of the commissioners asked you a question that arose from a comment from a law body. It was Nadell in particular.
Yes.
Where I think they averred that the philosophy, they feel that you're not according to the values and principles of our Constitution. That's what they said. And your response was, this statement is a mystery to me, and I think it is very, very unfair as no information was given. And I have never heard of any criticism of that sort ever. Now, they've repeated that comment now for this application that you. Has anything changed? So my direct question to you would be, in your own view, and I know the response you gave to Commissioner Toby, have you furthered the principles and values of our country's Constitution throughout your career and your judgments, and have you given effect to the transformative nature of our Constitution? Are there any examples that you can cite? Thanks.
So the complaint, what I did this time is firstly I wrote back to the Judicial Services Commission Secretariat, and I said, please could you speak to Nadell and ask them what the source of this allegation is. And the Secretariat said they don't get involved in correspondence. I then asked, I then reported on what had happened to the people that nominated me, because I thought I should tell them. They followed up with Nadell and said, please, could you give us the documents, the sources for your criticism? And they weren't able to produce any. The other element that surprises me is this. That is that Nadell, in fact, in 1995, supported my nomination as a judge of the Land Claims Court. I have done nothing in the last, 30 years, to invite that sort of a comment. I can't begin to fathom it, and I stand by what I said the last time. It's grossly unfair to put a comment like that before a body like this without having any basis to substantiate it. And yes, I believe that my entire approach to my legal career, from the time that I started in the legal aid clinic at Pietermaritzburg University, has been dedicated to realizing what ultimately became the vision of the Constitution. It didn't exist then. And as far as examples are concerned, there are a lot of them in my curriculum vitae, and I won't try and repeat those. The one I like to talk about is the one that I've already spoken to with Commissioner Ngugaya Toby, because it was a case where I wasn't just acting for, I wasn't challenging the state, I was acting for the state. But I brought about an approach that was also mindful. I suggested to my client that they subject themselves to an incredibly strict order to make sure that the disabled child in that case, who'd been the victim of negligence from the state, would be cared for and catered for the rest of his work, for the rest of his life.
No, thank you very much. Thank you, Chief Justice. I thought that the Eastern Cape example case would suffice to explain his position. Thank you.
Thank you very much.
Sorry, Chief Justice, can I just put on record more information in relation to that adverse comment? They said that they would get back to us, but they haven't done so.
Okay, no, thank you very much. I've seen no indication that commissioners who are on the virtual platform, that there's anybody who wants to ask a question. That being the case, I think therefore we have come to the end of this interview. Thank you very much, Mr. Dodson, once again for availing yourself. You are now excused.
Thank you, Chief Justice. Thank you, Commissioners.